Welcome back into the Money Matters Radio Network. Back again. I've been here since noon. It's, I don't know, it's pretty hot outside. It's about 77, 78 degrees. It is June 22nd. It is Tuesday. You're with June Knight. 2:04. My guest and co-host in the studio with me is Thomas Natoli. He is with the law office of Thomas F. Natoli. That's your office,
That
Thomas?
is correct, in Taunton, Massachusetts.
Well, welcome.
Welcome.
Thanks for coming by.
Thank you. We're not going to try to do too much heavy lifting today with this topic. It's definitely not the most glamorous topic of all, but if there is anyone listening right now, and I can guarantee you that you will learn something like this, and some of the mistakes that will result from not having a basic understanding of child support can really hurt you monetarily. So if you have kids now or you plan on having kids in the future, which will probably cover the grand majority of the people listening right now, you could definitely learn something like right now that'll help you in the future for sure.
Yeah, child support's what we're talking, or they won't want kids after they listen to the show.
Yeah, right. Hopefully that's not the effect that happens after this bit.
No, but hopefully they can arm themselves or at least get educated on what to and what not to do from you, Thomas.
Precisely. I mean, I guess the first important thing when you're trying to get the ball rolling on a child support situation, time is always of the essence. The longer you wait, it's very difficult to get retroactive decisions from probate judges. And what I mean by retroactive is if you wait, 6 months or so, and then you decide that you're going to file that complaint with the probate court to get child support, you're going to have a hard time getting a judge to rule that the hypothetical back child support of the 6 months should also be awarded in addition to whatever child support award is giving moving forward.
So it's almost like taxes then. If you don't pay your taxes, you have that interest that's been, just attached.
Well, exactly. I mean, in this case, you want to get it filed because what's going to happen is if you're the custodial parent, now in your standard child support situation, the mother is going to be the custodial parent. The custodial parent is the parent that has custody of the children, and then the non-custodial parent typically will be the father. Mm-hmm. The mother, at the point of either the divorce or if there is no marriage and there is either a boyfriend or there's a father, the mother's going to want to file a complaint for paternity if there is a question about who the father is. Now, with regard to the paternity action, these complaints are typically married to the complaint you're going to file with the court for child support. Okay, so if there is no marriage in place, okay, the court's going to need to know who the father is so that you can establish who the court will be summoning into court to establish a child support order. Now, in the case that there is no marriage, there is going to be a name on the birth certificate with regard to the complaint for the paternity.
So that's what we have to show, this birth certificate with the name on it.
Yes.
What else do we need?
Well, if there is no name on the birth certificate, then you're going to get into a little bit more complicated of a litigious process. There's going to be a little bit more litigation involved, but the safeguard that the court system and the justice system has in place for that is the attorney can file a motion for temporary orders, okay, with regard to either the child support or the paternity. So if in the case where, let's say you have a birth certificate that has no name on it, you now have no presumption for who the father is. So now, there's going to have to be a DNA test ordered by the court, okay? The mother, the custodial parent, still needs the child support. So what the judge will do is, based on the best evidence they have available at the time, they'll have a hearing and they'll make a determination for who, at least temporarily, who the presumptive father is, and they will also administer a ruling for what the temporary child support order will be. Okay, and now at least until, and these matters can actually go all the way to trial, from the time that you have this motion for temporary orders until trial, the custodial parent, whether it's the mother or the father, in our hypothetical, our mom will be collecting money from the presumptive father who's been, pointed out by the court in the temporary orders until trial.
Okay.
Okay.
So, Thomas,
yes.
How much should a non-custodial parent expect to pay in child support? What percentage of their income?
That's a very good question, and I think a lot of our listeners, that's probably one of the things they're most concerned with.
Yeah, that's what they want to know.
How much money? Show me the money, right?
Right.
Okay. These guidelines, like I said in the beginning, are very mechanical. Okay. Typically, you have very transparent, hypothetical, like optimally, you're going to have one non-custodial parent who's going to fill out a financial form for the court. The courts always require these financial forms to be handed into the court. The non-custodial parent will put their income onto these forms. The custodial parent will put their incomes on these forms. Ideally, we're going to have two W-2 situations where it's very easy and transparent for the court to make a ruling. Now, in terms of determining how much money, okay, you're going to have to pay, it's typically for the non-custodial parent, it's going to be in the 20 to 30% range.
20 to 30% of their income.
Yes, 20 to 30% of their income, and obviously, that's going to be a little bit of a sticker shock for a lot of our listeners, possibly.
Per child or per? How does that work?
The continuum that we're talking about with the 20 to 30%, that slides up when you have more children added into the equation. So if you have a family of 4, you're going to be more upwards in the 30% neighborhood. Okay, now I did say that these guidelines are mechanical. The overwhelming rule of law in this situation that the judge always has, as their ace in the hole to create the best situation for the kids is that everything revolves around the best interest of the children. Okay, so if you have a unique situation, for example, maybe your last guest you had on here had like a long-term situation. Perhaps you have a long-term care situation for a minor child. That would require more than the 20 to 30% of income. The judge still has the discretion to perhaps award more money to accommodate that situation.
Wow.
Which is good because we want in these situations the best interest of the child is always is what's going to be the hallmark of these decisions by judges. Now, mechanically speaking, they are very mechanical up until the point where the non-custodial parent earns $100,000 or more, or if the combined income of the custodial and the non-custodial parents is $135,000 or greater.
Everything changes?
Well, the judges have a little bit more latitude, and you're more likely to see a result where the judge might order even more than 30% in order to accommodate the children's lifestyle. The goal of these hearings is to maintain, the lifestyle for the children that they were used to, during and, before the marriage, after the marriage. Okay, or after the point where the non-custodial parent ends their relationship with the custodial parent or vice versa. So that might give the judge, a good opportunity to increase the child support amount from the mechanical guidelines the way they are to still maintain the lifestyle of the children. So, at the end result is that the children continue to, have the standard of living that they're used to, and that their cultivation and development won't suffer because the parents weren't able to, have a successful marriage or successful relationship for whatever the reason may be in that situation.
Mm-hmm. Okay, let's talk about this state. Let's talk about the Massachusetts Child Support Guidelines and how they work.
Yes. The Massachusetts State Child Support Guidelines, like many other states, in the olden days, decades back, the judges really had a lot more discretion in what it was that they were going to award. The whole idea behind the guidelines and their update a few years ago was to set more of a template, so that way, people, sitting here like me and you and our listeners can hopefully anticipate what it is that they're going to be paying for, their child support award if they're the non-custodial parent. Or if you're the custodial parent and you're filing that complaint for child support, how much money can I expect to be receiving from the non-custodial parent? That's important because, life decisions with regard to money, I think what's the statistic they always throw out there? Substantially higher. The highest usual reason why marriages fail has to do with financial matters. Okay. And
really?
Yes. And with regard to that, in this situation, if the more you can anticipate your financial future, the more you can have peace of mind, and you can hopefully take the best measures possible to not, to stay sane and continue your life in a peaceful manner.
What happens if, the non-custodial parent is not working? Or maybe is unemployed? That's
an extremely good question, and that is when, unfortunately, these litigation situations can start to become pretty expensive. The Massachusetts Child Support Guidelines has a provision for imputing income, or it's also known as attribution of income, and what that does is the judge has the ability to look at the non-custodial parent's work situation. Okay, the non-custodial parent has an obligation under the Massachusetts Child Support Guidelines to, in a good faith fashion, put a reasonable effort in to maintain, their ability to work at the same level or greater to whatever their academic accomplishments have been or whatever their past has been. So, if you graduated from, the Wharton Business School in Pennsylvania with an MBA, and then you decide that you want to go out and start your own lemonade stand at the end of the driveway.
Or build a plane or something.
Yeah, or build a plane or start a treehouse business. That's not going to fly in Massachusetts in the probate court, okay? Because of the fact that, again, the best interest of the children is what's at hand here. And you need to maintain, whatever it was that you were working towards. If, there's special, what if the non-custodial parent is going to, going to college, or the non-custodial parent is going to, is in grad school. There are special provisions that can deal with that in the child support guidelines, which we'll get back to.
And we will get back to that. Thanks, Thomas. 2:13 with June Knight, Thomas Natoli. This is the Money Matters Radio Network.